And welcome back. Joining us this morning for an extended conversation on the 13th Amendment and what it seeks to achieve are the Minister of Home Affairs, Karim Musa. Good morning.
Good morning.
And Attorney General Anthony Sylvester.
Hey,
gentlemen, good morning.
Good morning. Good morning. Sabrina, good morning. Isani.
Good morning. So,
good morning,
let's jump right into it, right? This proposed piece of legislation has caused quite a stir in Belizean society in terms of what this sweeping effect would be in how certain members of society move in their corners, right? So you have, on one side, proponents of this piece of legislation that says, okay, we're all for it and there's a particular reason and the reason seems sound. But then on the other hand, you also have opponents who are saying, no, this thing will impinge on one's constitutional rights and so on and so forth. Now, you guys are, in essence, the framers of this piece of law. Let's get your take from a layman's perspective in how this came to be, how you guys arrived at the point where you wanted to put this forward as a proposal.
Yes, so there are three very important aspects of the 13th Amendment, which I am sure we're going to delve deep into during the course of this conversation. The first aspect of it, which you can consider the more substantive aspect, is the fact that we are now moving away from declaring states of emergencies to declaring special areas. The second aspect of this 13th Amendment is the fact that we recognize as a government the intensity with which we are seeing an uptick in gun violence in the country. And we're not talking 9mm and 38 calibers anymore. We're talking big rifles that are being used on the streets of our country. And we want to create a specialized gang and gun court. That would also be seeing an amendment to the legislation to increase the penalty for illegal firearm possession. And the third aspect of the 13th Amendment is the validation clause, which essentially says all lawsuits up until May 26th, I believe, 2025, those can proceed, but any thereafter, meaning for the past SOEs, there will be a statute bar on those proceedings. So those are the three aspects. Now delving into the first aspect, meaning the substantive of it, let us recognize, just for 1 second, that in 1981, when we passed our Constitution, we included in there a provision that allowed for a state of emergency. Now, a state of emergency is not unique to Belize. We see it being used in Jamaica, we see it being used in Trinidad, and we have legal luminaries like Mr. McCoy, who is the Attorney General of Jamaica. He was the Attorney General of Jamaica, and he's a constitutional professor. He taught me constitutional law. He is the proponent of it in Jamaica. And again, it's similar provisions that we find in Belize, we find in Jamaica, similar states of emergency provisions. We have recognized that the state of emergency in 1981, as crafted for 1981, there was never that level of gun and gang violence in Belize. I think that's the first thing we need to recognize. And so in 1994, the then UDP administration passed legislation, not in the Constitution, but they passed it in the Crime Control and Criminal Justice Act, which allowed for a declaration of special areas. And so now you have these two provisions, the state of emergency and the special area declaration, because if you can recall at that time, there was an increase in the level of gang violence with the Crips and Bloods. It was getting more intense at that time.
And the Dragon Unit was the one that lorded over enforcing the law at that time.
Correct. So that was the reason for the presentation of that legislation. I think it was applied in the year 2011 or 2012?
2012.
2012, the administration had applied the declaration of special areas. Then in 2018, I think because it was being used in the Caribbean, the administration, the government of Belize then applied the state of emergency because we recognized we had that provision as well. And so since 2018 to present, both governments, successive governments, have been utilizing the state of emergency as a life-saving tool, because essentially that is what it has become. When crime and violence among feuding gangs becomes so intense that there is constant retaliation among these groups, and that oftentimes leads to the loss of innocent lives in Belize, not just gang members. Because there is this school of thought that says, let gang members kill themselves out.
But you have collateral damage.
There is collateral damage. And just in this year alone, think of Mr. Avelar, who died right here on Coney Drive outside your news station.
Yep.
Think of the young man Orozco on Ebony Street, who was just taking his child to school.
Yep.
Innocent lives, you know. Think of Miss Jones and her handicapped son. Those are 4 lives lost in just this year, as like you described, collateral damage. So the question is, what do you do when you have this kind of escalation in violence that leads to, yes, the loss of gang member lives, but also the loss of law-abiding citizens' lives? That is why we're saying we need to have a legislation that can counter this, because, as you and I know, Isani and Sabrina, in the streets, there is a code. If I kill Isani, Isani's family will not say it's me, even if they witness it. They will take out the retaliation themselves. There is a street and a gang code that we have to recognize.
It's understood at this point.
It is understood.
That's how it's played.
You cannot get a statement from anybody family who was involved in a murder resulting from gang violence. And so we recognize that problem. If you recall our former commissioner of police, and he wasn't lying when he said this, Chester Williams, he said, we know every single gun we bust, who bust it. He said that.
Yeah.
So then the question is, well, why police can't stop it? That's always the question.
The evidence.
Yes, because someone has to go in and give a statement.
Yep.
In order for us to charge someone, someone has to give a statement. Or, as we have been moving in this direction, you have to have evidence like a CCTV camera, or you have to have forensic evidence. We recognize those are all complementing evidential material that we have been utilizing. But what happens when you don't have a camera? What happens when the gang say, well, we're going to commit the murder over there because no camera not there? So we need a legislation that allows space for the police that can hit the pause button. And what happens during a state of emergency? 1, many guns and ammunition are taken off the streets. In just the last few SOEs, 130 guns, 2,000 rounds of ammunition taken off the streets of Belize. But nobody's talking about that. But imagine, that's 130 lives
Was that the result
saved.
was that the result of a swap, or was it the result of actual going into these neighborhoods and doing a sweep to
It is
collect these
mostly
weapons?
operations, Isani. It is operations within these areas.
Well, let's take a step back really quickly, because one, we have enough time to really look into this amendment. We do want to also include some questions from you guys tuning in as well. I know there are quite a few interested in this topic online. But one of the first conversations that we have been having is the title in itself. We're calling it special areas versus the state of emergency. We've had several persons on the couch with us from legal backgrounds look at this amendment. And one of the first points raised was sort of kind of like it's a different name, same story. What's your reaction to that?
It is being, like I said earlier at the introduction, we are fleshing out the state of emergency into the Constitution, but fleshing it out in a way that you're saying specifically. Because the state of emergency is only for public safety. It's very vague. Now you think of natural disasters and the looting that happens in natural disaster, and you might say, well, maybe that's what the framers of the Constitution wanted, for us to have legislation that addressed that. We're saying now in 2025, as was recognized in 1993, that we need to flesh it out more to say this is a crime-fighting, life-saving tool that we want to keep in our toolbox as a measure of last resort. Not something to be used every single day, but rather something to say, listen, this is getting out of control. The public is not participating, not giving statements, not getting evidence, we need to hit the pause button.
I'd like to parallel both of them and show our viewers how it differs.
Correct.
The state of emergency being in place, we know as a tool used to essentially ensure that the public feels a sense of safety when there are a rise in crime, at least for the case of the violence taking place, because states of emergency can be put in place for other reasons as well. How does that differ from the special areas and from the Constitution that we are now seeing being amended here? I want a clear picture of how the state of emergency is put in place and what those rules involve and how it differs for the special areas.
Sabrina, to go back to what Minister Musa was explaining, one of the operating rationale behind the need for the amendment at this particular time also arises from the fact that there has been two conflicting court decisions. So in one of the court decisions, one of the judges declared and ruled that yes, government can use a state of emergency provision to fight crime. Another judgment, the judge ruled no, you cannot do that. And in fact, the judge went further and to say, well, this should only be used when they actually arise public disorder to the point where it almost cripples the government's ability to have law and order be maintained. So the government is faced with this dilemma where you have two conflicting decisions, and as any government, any responsible government has to do, it has to ensure that there's certainty in the law, which is to your point. And the 1981 provision, as Minister Musa explained, they are rather general, deals with all matters of states of emergency and public emergencies. So he wanted to make it be very clear that where there are instances where crime has escalated to a particular crescendo point, that these are the provisions that are to be used. And we are not utilizing provisions which are new. They have been in the laws of Belize since 1994. And all that is being done.
Quickly, AG.
Yes.
Couldn't this conflict between the opposing rulings perhaps be dealt with or clarified in the appellate jurisdiction, as opposed to the government saying, okay, you know what, we could skip any other processes and just seek to amend the law and have this be the end all be all in terms of the legal framework that deals with it?
So that's a very good question. So the matters are actually on appeal. So in relation to the judgment where the court said the states of emergency can be used as a crime fighting tool, those claimants are appealing. And in relation to the decision where the judge said that it's not, government is appealing that decision. However, as you are aware, it takes time before a matter moves through the appellate process. However, within the next 2 years, 2 to 3 years, whilst that move, the government or the state still would need to address citizen security. There is a real possibility that crime may reach a particular level where there would need to be the invocation, need to be the application of such a measure. And so what is being done is to say, yes, the court made these rulings, but for certainty, moving forward, these are the provisions that will be used to address the situation where crime has risen to a particular level.
Let me go in a slightly different direction, but still within the scope of what we're discussing here. In private practice, both of you gentlemen have defended or represented people who would have been written off as gang members. In your case, Minister Musa, not for anything political, but you've been an opponent, of state of emergency prior to taking office in 2020. You were harsh against what the then government was doing in terms of trying to curb crime or keep a lid on it. Now you find yourself in the very same position where you're referring back to the state of emergency as a means of being able to curtail crime and violence. How do you look at it from the other perspective, where one, you are against it, now you're batting for it?
That's a very good question, Isani, and certainly it does allow an opportunity for individuals like myself and like Anthony, who are proponents of human rights and the rights of all defendants in cases. It gives us the opportunity to reflect and to recognize the great privilege and position that we currently hold. Because yes, as attorneys, it is easy for us to criticize from the outside. And I would want to use that very argument to say that is why you should have trust in this process, because it is individuals like myself and Anthony who have seen, who have had oversight over this process, to know that it's not going to result in the kind of rights deprivation that a lot of the fearmongers have been saying, a lot of the noisemakers. And so being in this position, Isani, you recognize that you're not just representing defendants, you're representing the families of not just the victims, but also individuals who are caught up in this life of crime and violence. The shooters, because some of the parents call me as minister, some of the victims' families, and say, Minister, why is it that you did not call a state of emergency? Why did you allow my son to be killed? And so there is a lot that is on the shoulders of us as ministers that was not on our shoulders when we were just attorneys fighting for the rights of individual members who might have had a grievance and who might have had their rights deprived unnecessarily or unjustifiably. And one of the things you might notice since our administration came in 2020, prior to 2020, in those states of emergencies, you would see a lot of people rounded up. Individuals who might not have been involved in crimes leading up to those states of emergencies, 2018, 2019, 2020. They were just rounding up everybody. And so one of the things we recognized is, listen, a lot of these individuals want to be a part of a process that can rehabilitate, that can see reform. They want to change. They don't want to be in that life anymore. So why round them up? And so what we look at from 2020 to 2025 is a more targeted approach. If you see some states of emergencies, only 30 individuals were picked up. In the last one, I think some 40, 45 were picked up. A lot less, a lot more targeted, because we, as lawmakers, ensure that the police, when they are putting forward this and this individual needs to be picked up on reasonable suspicion, they have to make out a proper case. And that is what this new legislation offers, Sabrina. Every single aspect of it, whether it's a search, there must be reasonable suspicion. Whether it's an arrest and detention, there must be reasonable suspicion. And so again, it's a lot more targeted, and it's not just the minister that's going to decide this moving forward. This is an important point, Isani. It's not just the minister, it's not just the prime minister, it's not just the commissioner of police that gets to decide this anymore under this law. It is an entire National Security Council made up of the military, made up of the Coast Guard, made up of foreign affairs, immigration. All of these parties who belong to the National Security Council must now listen to the report from the police and say whether it is justifiable that we now call an area a special area for 1 month. Similar provision to the state of emergency, now with greater oversight.
I can agree. I can see with that part where it's more than just one person or one group that's involved in the decision making. What I want to refer to at this point is what you mentioned earlier, the statute bar for all other claims that would come against the government based on previous SOEs. Now, while this particular issue, the most recent one where the High Court ruled both ways, was not an issue that formed under the People's United Party administration. Admittedly, it came from the UDP back in 2020, right? But my point here, or leading to the question, is the fact that when these young men were picked up, it would have seemingly been in an indiscriminate manner, is what we would describe as a dragnet, right? You cast, and then you have people who perhaps have legitimate reasons as to why they're filing a claim against the government of Belize for that. And now you're saying that based on this statute bar, they won't have that right to be able to challenge it?
No. That's not what is being said. So,
Okay.
that provision in section clause 18 B of the bill, what it seeks to do, it operates as a validating provision. In other words, and this is nothing new. I brought an example. So in our current constitution, section 145, there is actually a provision which is called a validating provision. So that something that may have been done in the past, it is now being validated. In that particular instance, you have this relates to the BTL, BEL acquisition. So the government may have passed legislation. The court initially declared it to be unconstitutional. It was done a second time. When it was done a second time, the government said, look, so as to ensure, even ensure that what is being done will be safeguarded, it was inserted in the Constitution. And that, if you were to actually look at that, read section 145 and look at the clause in the amendment, it actually mirrors each other. The other provisions in the Constitution, I think it's 75 or 79, which also is a validating section. So, for instance, in the House of Representatives, if the House were to conduct business and you have a member who should not have, who was disqualified, but you took part in the vote, the House proceedings and the result would still be considered to be valid. So, what needs to be firstly highlighted is that this validating section, this validating clause, is nothing new. It's in our Constitution. It is something that is utilized. I was sharing with the minister yesterday. I found another example. We have, for instance, an amendment in 2021 where you had a validation provision relating to the Court of Appeal Act, so that all hearings that may have taken place from 2004 and whether there was proper quorum or not, all of those decisions are being validated. So that's something, firstly, that has to be highlighted. Validating provisions are things which are part of the law, and there's nothing sinister, there's nothing untoward about it. Secondly, statute of limitation also is a part of our legal system. As things stand, you have a legislation known as the Limitation Act, which actually carves out a 1-year limitation period for persons to bring actions against the state. What the clause does, it actually puts a limitation period, and that limitation period is at the 26th of May 2025 when the bill was introduced. But all those previous claims that were filed and the judgment, they are still valid. Okay. So those persons' rights are not being taken away, they're not being extinguished. And I'm not quite sure how is it that we arrive at that point where it was thought that that was the purpose or that was what was in the bill. But if you actually read it, it's very clear that those persons who had existing claims and who had judgments against the government, those are still valid. And the only way those can be reversed is that if a higher court, an appellate court, were to then declare that their decision or the judgment in their decision should be set aside. So we just needed to make that extremely
Thanks for the
clear.
clarity on that. Yeah. I want to go in another direction now to speak on the consultation process, because when we poll, and this is an informal poll being done by us here at GBM, or even when we speak to the average man in the street, not too many people are actually familiar with what the government is setting out to do by way of this proposed piece of law. A lot of people are still very much confused, which begs the question, how much public awareness has been put into educating the masses about this particular move?
Yeah, Isani, and this was one of the points that the Attorney General and myself recognized leading up to the first consultation hearing. is the amount of misinformation, and there's nobody to blame except perhaps ourselves and perhaps the administration in not coming forward, because yes, the Prime Minister did give an opening explanation when he presented the 13th Amendment. I've been on the media, I think twice, speaking of maybe one aspect of it, that it's an old law that we're just upgrading to the Constitution, but actually fleshing it out and having a discussion like this, I think is very important, and perhaps not too late, because it is a 90-day period. And of course, the ones making the most noise will of course get the most attention and perhaps the most traction as well. And so it's important to have this balance. But let me just say, Isani, that I think the consultation process is an excellent opportunity, and I'll tell you why. We have heard positions coming from the defense attorneys. We understand where their position is. They're against states of emergencies altogether. So the argument that they're having right now is a 1981 argument, because this law is actually better, has greater oversight than the 1981 state of emergency. But that's what they're tackling it from. In terms of why I say it's a good process, a healthy process. Anytime you touch the Constitution, you must get this type of emotional reaction. I would have the same reaction because I want to learn more. I want to see where this is going, where this is headed. But on the margins of the consultation, the first consultation, one of the contributors came to us with an excellent suggestion. It wasn't on the mic, it was on the side. She said, ministers, in that 1 month period, why not include a provision that allows an individual who might feel they have been unjustifiably picked up and that there was no reasonable suspicion for them to have been picked up, why not include an emergency application to the court for that individual? So if I pick up 20 and 5 of them feel, listen, I don't know part of no gang, I ain't no boss no gun, I want to make an application. Why not allow an emergency application to be included in there to the High Court, and for the High Court to determine within that month on an emergency basis, an urgent basis, to determine whether or not there was any reasonable suspicion for that individual to have been picked up. Now, that's something I am open to, and I'm sure the Attorney General is open to, and I'm sure the Cabinet will be open to, because it's a good contribution. And so that is the type of contribution that we're looking forward to during this consultation process, because we could say over and over that this is a better law than the 1981 SOE, but at the end of the day, people will still tackle it because they see it as you're touching our Constitution, and we respect that.
No. I just wanted to say, well, I hope that person actually puts the recommendation, the suggestion, which was made to us in writing, because what needs to be realized is that, appreciated, that this is a part of the House Committee's deliberation. So it's already been, the bill has been tabled, so people actually formally have to put their suggestions or recommendations in writing, so that the committee members, they could consider all of it and they could then make the requisite amendment. But that was an excellent suggestion, because that would then deal with and address the concerns that people say, but just have these young men or persons being locked up for a month, and they'll have to wait until the government actually establish or comprises tribunal. And this amendment, which I love myself, would allow for persons to be able to apply in emergency situation, and so straight away, you don't have to wait until any 30 days or whatever the period of the state of emergency. Because of another thing, it says that it's up to 30 days. It doesn't mean that it has to be for 30 days, you know. And all of those considerations would be done by the National Security Council. So, for instance, when the matter is triggered and it is placed before the National Security Council, you would have persons who would say, but why only need 30 days? Why not 20 days or 25 days or whatever the case may be? So, again, these mechanisms which they actually are enhanced and better than the current SOEs, which doesn't allow for those.
We need to go to a commercial break, but I need to throw this in really quickly. So, a lot of these young men who stand to be affected by this may not have the benefit of legal representation for judicial relief. So they get scooped up, right? You're saying that there can be an emergency application for the High Court to decide whether those who came in and swept them up had everything intact before doing so.
Yes,
a lot of these young men don't have attorneys on standby, don't have the wherewithal to pay for that kind of process. So in a sense, they're still very much marginalized.
Well, I would suggest otherwise. I've seen a lot of claims coming in and a lot of representation, and so I would disagree. There are attorneys who are, which I applaud, who are diligently ensuring and holding the government to task and approaching the High Court, making necessary applications for constitutional relief and otherwise when it should be. So there are attorneys out there who I'm sure would take up the challenge and approach the High Court on their behalf. No.
All right, well, we do have to take a quick break, but when we come back, the conversation continues. I know that there are several conversations surrounding trust in police as well, and if these persons in authority will be able to carry out their role without bias. When we come back, we're going to continue this conversation.
My name is Leomar Langzert and I'm a teacher and I bank with Belize Bank Independence Branch. What I enjoy is the safety features that the app offers. I have a sense of not having to worry or be concerned about somebody finding my password and username to sign in the application because of the use of the one-time password. And another feature that I love, that I use the most, is how the app synchronizes with my fingerprint on my device. I enjoy the rapid and easy, seamless process to apply for loans through the Belize Bank, and I don't have to be having too much back and forth to visit or take time to visit the bank. They also start to offer the online applications through the app for loan applications, which I believe is very neat. I would definitely recommend Belize Bank to other teachers because one of all the features and advantages that the app offer with these online that Belize Bank offered is basically everything that you can do in the palm of your hand. So I would definitely recommend the bank to other teachers.
Welcome back. We're continuing our conversation with the Minister of Home Affairs and the Attorney General with respect of the 13th Amendment. Now, we want to go into another direction where this conversation is taking us. In Trinidad, you have the 6s and the 7s. Just as much as in Belize, you have the Crips and the Bloods, right? And so both governments are grappling with ways how to address this situation meaningfully. If we look at Trinidad as a case study for why officers in law enforcement in that country have been given what can be termed as sweeping powers. They don't need a warrant, they don't need a lot of things to just go into a neighborhood and pick people up and lock them up if they believe or suspect that they're involved in gangs and criminality. In Belize, we're saying, look, there's already an erosion of public confidence in the police department to be able to carry out its function in a civil manner. A lot of people are claiming abuse and so on and so forth. How do we know, or how do we take comfort in the fact that while they now may have this once it's passed, to come into a neighborhood and just pick up a group of young men, kick down your door if they suspect that you have guns and drugs or whatever the case may be, that they're not abusing this particular authority being given to them.
Yeah, so if I may just quickly, AG, I think we're dealing here with oranges and apples, but indeed some of these oranges fall into the apple basket in the sense that police carry out operations whether they're states of emergencies or not. Police will come into your home based on reasonable suspicion. There's no requirement for a warrant if they suspect you have guns and ammunition inside your premises. So that's something that's going to happen regardless, because the police might have intelligence that in fact you are housing guns and ammunition and drugs in your premises. So I think in that sense it's oranges, but it's probably more heightened when you have a state of emergency, because there's a wide sweeping operation that takes place inside a special area, as this provision here is proposing. And so what you then see play out, because people know that police are coming into my neighborhood, is that everything is documented. Police picking up individuals resisting arrest. That is very common because nobody wants to go to jail. That's the reality. But the issue then arises when you have the entire community coming out to defend an individual who the police are seeking. And so then you have that negative interaction between the police department and the community. But at the end of the day, I think that if we are to be objective about it, there has been a steady decrease in the amount of police abuse cases. We used to have the GSU that used to wear masks, that used to break down your door, that used to really abuse citizens' rights. We have disbanded that unit. We now have the GI3 that's more intelligence-led operations and a lot less abusive, if I'm to use that word very loosely, than what the GSU represented. And so, like I was saying, that's something that will always perhaps exist in situations where people are resisting arrest, but at the same time, you do see it more during an SOE.
You have a community like Mayflower, right? Ghost Town, where you have a heavy concentration of people living in one small neighborhood. So law enforcement descends on that community on a raid or what have you. And in many cases, in the aftermath of that operation, you have all of them ladies will come out and they rail up about and kick down their door before they look for somebody or what have you. Are those complaints ever really addressed? Because it happens from community to community. Same thing happens in PIV where you have a concentration of people in land barracks, but not everybody they harbor, or not everybody has a son who's a criminal or wanted, but they too feel the effect of these kinds of operations.
And why can't you just charge a person for being a member of a gang?
Yeah.
So very good question, and that is why that is the second important aspect of the 13th Amendment, is the creation of this specialized gang and gun court. So it's not just our recognition that in fact guns, the prevalence of guns and the high-powered guns that are on our streets that require us to address that in an urgent fashion, but there's also the issue of the gang legislation that Sabrina is referring to. Under our current laws, if you are found guilty of being the member of a gang, you are supposed to get a 10-year sentence for being the member of a gang. If you are a leader of a gang, you are supposed to, under our legislation, get a 20-year sentence. Imagine that. But what we find happening at our magistrates court level, and I can't knock our magistrates because perhaps some of them are in fear of their own lives, is the fact that when a defendant pleads guilty to being a member of a gang, we do not see a 10-year sentence. That's a reality. What we see is a $1,000 fine or a $2,000 fine. No kind of prison sentence whatsoever, when in fact this is one of the big problems in our society when it comes to crime and violence, is these gangs.
Here is the irony for me, right? So every so often, a group of young men are rounded up and charged for being members of a gang. But all gangs, if you look at their organizational structure, have a leader, have someone who they answer to. But in most cases, that very same leader is a person that's working with the LIU and what have you, but they don't get charged for being gang leaders. We all know who these players are. So what happens there?
So if I may just quickly, AG, when it comes specifically to that issue, the leaders have a good way of hiding their hands, Isani, and so the intelligence that we're getting won't trace back to a leader. So a leader might set you up to go do a shooting, but what the police learn from the victim is that so-and-so shot him. But how do you then prove that that shutter was directed by the leader to have done what he did? When you go to the leaders, you know what they tell you? Boy, the young boy there, you can't control them. They got a mind of their own. I know even the deal with them again. That's what.
That's a couple. We've all heard the same thing. You from a law enforcement perspective, I from a reporter's end. That when you approach these young, and we are, like I said, we all know who the players are. When we approach them, they'll be the first to wash their hands off of it and say, "Man, I got nothing to do with that. The young boy out of control," right? But when there's conflict and when there's ongoing tension, you don't go for the young men. You go for the supposed leaders. You sit down with them and try to broker some kind of truce or what have you.
The ones who the police have reasonable suspicion of are detained, but like what you said, in many cases, the police cannot have that reasonable suspicion or cannot trace it back based on intelligence to the leader, and so it cannot be that we just pick up everybody the way we used to. And so, like I said, it's more targeted, that you pick up the ones that you know that you have reasonable suspicion of. But I take your point that in fact there may be bigger hands at play that are moving the chess pieces, and so again that would mean more people getting detained though.
Yeah.
I just wanted to go back a little bit on the issue of the prosecution of these gang-related crimes. So, as things currently stand, matters are being dealt with in the magistrates' court. The plan is, and the idea is, to have these be dealt with in a specialized gang and gun court. Now, in magistrates' court, the magistrates deal with all types of matters, traffic matters, and all other types of matters, including civil matters. So what you have happening is that a case may have started in January, but it's not completed through no fault of the magistracy until perhaps maybe within a year, because it's adjourned for a number of times. The idea is to remove that and to have these cases be dealt with as somewhat similar to in a high court, which is why the amendment is to have the court have the powers of both a magistrate and a high court judge. And so, and again, with respect to a specialized court, and it's nothing new in Belize having specialized courts. In other countries, you have specialized courts who deal with family matters, revenue matters, administration, estate matters, whatever. So the idea is to similarly have a specialized court. They deal strictly with gun and gang matters, and that will allow for expedited hearing. And that experience has shown it allows people to be brought and held to account in a very shorter period of time. And that has a domino effect. Persons are able to see they were charged in January, and also it also restores confidence in the public. And by October, that person's trial has concluded, that person has been convicted. These are things which send a signal to would-be gang members and persons who want to get involved in the criminal justice system, and it also send a signal to the public that the system is working. So that was the rationale, and that is the rationale for that particular gang and gun court being a specialized court. No,
I want to really quickly highlight something that we've been hearing a lot of concerns from the public regarding general rights in these special areas. Persons feel that when police officers come and try to detain an individual, that all their rights are null and void. They can't necessarily pull out their phone anymore and record if they feel that they need to protect themselves and what is taking place. I want for both of you gentlemen to share with the public what are the rights that individuals may still have in these special areas.
So let me just start, and then Minister can come in. But so once the police is in the process of detaining you, so your right to free movement, that automatically is limited.
Yes.
Because if you were to run, you could possibly be charged for, obstructing the police officer in execution of his duty, escaping, etc. Really, I think sensibly, I don't see how, if the police is coming to arrest you, you can be allowed to take out your phone. And
Can other individuals around pull out
Yes.
their device and record?
certainly, certainly.
No one has ever been charged for recording, and I actually encourage.
Well, not necessarily charged, but we have seen video clips where police officers have
and those
pulled
individuals, and the police officer that slapped the individual's phone at Maya Air was charged. And so you do have a charge of assault if a police officer hits the phone out of your hand. What I have an issue with, because yes, I do encourage everyone to video record their interactions with police. What I naturally have an issue with is the fact of when you do find the video, it's a splice video that only shows the end result. They don't show you the part where they're
full
hitting the
interaction.
police. That results, correct,
Yeah.
aggravating the situation, resisting arrest, obstructing. I recall the issue in Paraiso just a few weeks ago. Those individuals had pint bottles and batons. And perhaps an argument could be made that the officer was using his baton excessively in the bushes. But in fact, you don't see what triggered the police to have even reacted, because they are being attacked. And so there always has to be justifiable use of
Granny get
force.
wrapped up in that incident there, and I think that's where some measure of discretion has to be
Absolutely,
exercised.
I agree.
We need to contain the conversation.
Even though the granny might be aggressing. But
Yeah.
I agree.
Let's contain the conversation to the 13th Amendment here, though. So there's a 90-day period that we're looking at. What does the timeline look like in terms of being able to take the consultations on the road? Because at the end of the day, it's not only a Belize City thing. Everybody from north to south, east to west stands to be affected once this goes into law. Let's go.
So, as I understand it, I don't sit on the committee. I was only an alternate sitting on the committee on the first consultation hearing that was held last week. And so my understanding is that the committee is planning a second consultation hearing in the Cayo district. I believe that should be, if not next week, maybe the week after.
When we think of consultation, one of the things that I've also considered was consulting persons who are specialized in the field of sociology as well, social workers, anthropologists. One of the notable figures that I have followed his work has been Dr. Herbert Gale. Has there been any consideration in consulting him for his study that he's done on gangs and crimes here in Belize as well?
Yeah, so there has not been a one-on-one consulting, but I think that Dr. Gale has many writings that he's published. He has appeared on your show. He has done a lot of public forums on crime and violence in the Caribbean specifically. And I have to say that a lot of what we take here in Belize is in fact generated from policies and principles as he has put forward. And one of the interesting things that may have surprised a lot of people when Dr. Gale appeared on another talk show was the fact that he endorsed a state of emergency. And I think that came as a shock to the host of the show, because he said there has to be a mechanism in place that you can hit the pause button. What he has recognized in the past is a lot of politicians might use it as an injection of morphine, he calls it. You don't want to get addicted to a state of emergency. You must use it only in exceptional, rare, last resort cases. And so, again, it's important for us to hit the pause button when there's this escalation to allow, and I was saying it earlier, to allow for us to get the guns and ammunition off the streets, for us to charge individuals based on investigation, and for us to have mediation. Perhaps the most critical part of a state of emergency is the mediation and intervention. And when you get to the bottom of it, Isani and Sabrina, you find that these young men are killing each other based on rumors. I'm here, Isani want to kill me, so I kill him first. And then that just spirals out of control, but it may never have been the case that I said I wanted to kill Isani. And so that is one of the reasons why a state of emergency, and as we're now proposing a special area, is important for us to have these mediation sessions.
I wouldn't want to dismiss. Yes, go ahead.
I just wanted to add further, in response to your question, Sabrina, generally in terms of consultation and sharing of ideas. So there's this regional body known as IMPACT, the CARICOM Implementation Agency for Crime and Security. So all regional countries are part of that, and so generally there is a sharing of ideas and engagement and discussion as it relates to addressing this very critical issue of crime and citizen security. And the ministry, both Ministry of Home Affairs and the Attorney General's ministry, so we receive daily updates and information that is being shared. I think in Trinidad, I saw an email yesterday that they're having this training in Trinidad, and so these are things that in real time we receive, and we try to use the information to shape the policy and with respect to addressing crime.
I'm not here to discount or dismiss the work of any sociologist or social scientist where studying crime and violence in this region is concerned. I think they've done stellar work. But for me, the issue remains the same. So if you look at what's taking place in Jamaica, we look at what's taking place in Trinidad, we look at what's taking place in Belize, and if you look at what's happening in the smaller islands within the Caribbean, because the movement of gangs and the stronghold that gangs have isn't confined to just these three countries that we're talking about. But social scientists and sociologists have studied this thing, have written about the thing, and it's only gotten worse, right? So while we take what they've put in writing and based on research and studies, it does not, for me, identify a clear solution as to how to go about doing so. Yeah. And even if that's the case, it's not a one-size-fits-all.
Yeah, so I have thoughts on that too, though, but I'll get your...
Excellent point, Isani, and that just goes to show you the complexity of crime, and even more complex the solutions that we're talking about. Because just now when you asked me the question, Sabrina, I only answered one of the things that is endorsed by Dr. Gale.
Yeah, and I wanted to also give feedback on that. I didn't go to the very root of what Dr. Gale proposes, which is a social intervention into the lives of these young men in terms of economic opportunities, employment opportunities, mediation that takes place, and intervention that our LIU is doing. And so I want to make a very bold statement right now. 2018, we used a state of emergency. 2019, 2020. It never resulted in any drastic reduction in crime. It only paused the situation to allow police officers to do their work, to get guns off the street, to mediate. The difference between 2018 and 2025, where we're now seeing a drastic reduction in the number of homicides, is the LIU. That is the difference maker. And so you have an almost 50% cut in the homicide rate, which you're not seeing in any other Caribbean country, because they perhaps are not taking on this social intervention program that we have. But having said that, even though we're doing all of this work with the LIU, does that then mean we will allow only a handful of individuals who are not a part of the LIU, who do not want to change, to hold the entire society hostage, including law-abiding citizens? There must be a solution for that. And so, going back to the point I was making, I totally agree, and I always say this, and Anthony always says this: the 13th Amendment, the SOE, the 1994 legislation, those are not solutions to crime. Solutions are tackling it at its very root, which we're doing. But while we're doing that, we have to have a remedy also for the individuals who are hell-bent on wreaking havoc. And I'm glad you made that clarification, Minister Musa, because I've also followed the work of Dr. Gale. I've also listened to his interviews that he's done on other media outlets, and I struggled to accept that he supported the state of emergencies, because he has been a proponent of all of these social projects to tackle the root cause of crime and violence in these regions. And so even your point that you mentioned, Isani, I struggle to accept that as well, because I don't believe that we are looking at the results of giving these projects and these initiatives a fair chance. Correct. Why? Because they're more long-term. Yeah. When we think of crime and violence, we think of the impacts that are happening right now, and the people that are dying, and the collateral damage that is taking place. And so while we recognize the importance of long-term solutions, there is also I guess we can say the state of emergency providing a shorter term solution for what is taking place, and we cannot deny that.
But many would argue that it's a band-aid solution.
And that is also why I mentioned the
Again,
SOE
not a
being a
solution.
short term.
I don't even
I'm not
classify
the
it
one
as a
saying that.
solution. No,
That's a prevailing thought.
and that's how we need to change the way of thinking. It is not a solution to crime. You're
So
not
then, do
tackling
you
the root
believe
causes.
that? Do you believe, because you mentioned that Dr. Herbert Gale said that the state of emergencies are effective. However, we shouldn't be running to it for
100%.
everything. You know,
I 100%
do you
agree
believe
with
that the current administration has been running to the state of
No,
emergency?
I do not. Nor do I think the last ones have. It may have been a larger net that was cast under the last administration, but I don't think that it has been utilized over and over again, or else this last one that we had, a month, so many people were saying give them 3 months, but no, we had
We
already
heard
done
the commissioner say
6
he
months.
he would
Six
be
months.
upset with 6
Yes,
months.
but what you have to
I
look
would
at,
agree with that.
what you,
Okay.
yeah, he would not agree with that either. What you have to look at, Sabrina, is the level of threat, the threat assessment that is carried out by the police department. You have to look at the mediation and intervention sessions. And in this instance, the last state of emergency, it came to reality that in fact there was not that threat. For an entire month, I believe, after the state of emergency, when these young men were released, there was no crime and violence and no retaliation at that time. Obviously, with the recent spike with the gentleman on TikTok and saying what he said and the resulting violence, that's a whole other issue that came out that is unrelated to the last state of emergency. So I agree with you that you have to use a state of emergency, or in this case, a declaration of special area, only as a matter of last resort. One, to prevent the continued loss of life, whether of gang members or of innocent civilians. It cannot be something you go to every single month.
All right.
And to just to reinforce the point, it's a necessary and important tool that the state must have. I mean, recent events in Trinidad. So the current government, I think it's only two months since in its administration, and it had to implement a state of emergency that it was critical of the previous administration. So what this certainly to me shows is that it is an important tool that a state needs, and comments, criticism, critiques may be made, but ultimately it has to, and it's necessary where it's justifiable and upon reasonable suspicion, and those mechanisms that have been inbuilt in the 13th Amendment, as we say, it actually is not there in the current SOE regime in the Constitution. So it's actually an enhanced and improved way in which addressing crime, detecting, investigating, and controlling crime would be able to be done in a balanced way, both in terms of the citizens' rights and in the public interest for the general citizenry.
All right. Well, gentlemen, we have one last opportunity to take a break and come back to you guys. I will encourage viewers tuning in online to also state your questions, because this will also be an opportunity for us to share some of your thoughts as well. We take a quick break and we come back with more.